people who are in the custody of law enforcement have a right to privacy. And if you talk to them with law enforcement officials present, you have violated their privacy potentially. The sort of correct course of action is to ask for some distance, maybe bring in hospital security instead of LEOs to sort of provide safety. Welcome to Critical Care Time, the podcast for everyone who cares for the critically ill. I'm Dr. Nick Mark.
And I'm Dr. Cyrus Askin. On today's episode, we're going to talk about a situation that comes up almost every day. Someone who is critically ill and in the custody of law enforcement.
We're going to use a series of cases to discuss the moral, ethical, and legal implications of providing critical care to people who are in the criminal justice system. Hopefully, we can highlight some of the challenges and help our listeners avoid pitfalls when providing respectful and ethical care to people in the criminal justice system. We're fortunate enough to be joined by two expert intensivists to talk about this subject with us.
Dr. Erin DeMartino is a pulmonary and critical care physician and medical ethicist at the Mayo Clinic. Her research focuses on the intersection of health policy and ethics at the bedside of people who are critically ill. She investigates fairness in scarce resource allocation and how state policies influence medical decision-making for patients lacking decisional capacity.
Dr. Matt Griffith is a pulmonary and critical care medicine physician at the University of Colorado. He's a health services researcher whose research focuses on evaluating and addressing disparities in the delivery of medical care for chronic pulmonary and sleep conditions. Erin and Matt, welcome to Critical Care Time.
Thank you.
Thanks for having us.
It is our pleasure. All right, folks, get excited for a great interview about this important and tremendously underrepresented topic.
Quick disclaimer up front for anyone who doesn't stick around for the very end of the episode. Just remember that our guests and us are not speaking on behalf of their employers. Also, remember that this show is intended for medical education and should not be used in lieu of actual medical or legal advice. Familiarize yourself with local laws and get a real lawyer if you need one.
Also, shame on you if you don't stick around for the whole episode. Just kidding.
Yeah, please, come on. We have to tell you to give us a 5-star rating on iTunes, so don't try to get out of that. Okay. I think, one of the most important things about understanding the experts in this space is understanding why they're experts in this space. Erin, if you can you tell us your superhero origin story? What got you passionate about this issue?
Before I started fellowship, I had very little interface with patients who were incarcerated. And Mayo Clinic is co-located with a federal medical center, so one of 6 referral centers for the federal prison system, which is located in Rochester, Minnesota. And all of a sudden, I was both as an inpatient and outpatient clinician interfacing with this patient population and trying to navigate those interactions without having received any prior education around them. And I remember a particular case in the intensive care unit with a patient who was dying with end-stage COPD and declined intubation, shackled to his bed. And the discomfort that my attending physician had around respecting his wishes, whether we should defer to the warden or the medical director at the prison, whether we could ask for the shackles to be removed, how to go about that process. And that kind of indoctrinated me into the struggles of caring and upholding the dignity of this particularly vulnerable patient population.
Wow, thanks for sharing that. Yeah, I think there's a lot of issues there that we will hopefully touch on today. Matt, do you want to share your origin story? What got you passionate about this topic?
Sure. I had a similar episode to Erin where I had a patient who had chronic lung disease and was incarcerated and was in RICU in the county hospital where I did residency. And, even though despite the fact that she was intubated and sedated, was shackled to the bed. Also, the thing I think that got to me the most was the restrictions that were placed on visitation. She had a large family who were all in the sort of waiting area every day, and only one person was allowed at a time to be with her, even in her final moments. And yet there were, 2 officers there at all times. And it just didn't seem kind of right that this person, who's not a threat to anyone, was denied kind of, and her family were denied access to her at these critical moments just because of, the decisions made by the officers at bedside and hospital administrators. And so, that was a case that I've took care of her 10 plus years ago. It still sticks with me.
And can you tell us about the organization that you both contribute to that's trying to set right some of these problems?
Sure. So Scopes and Shields is an organization that was founded by intensivists, members of the American Thoracic Society, who kind of came together through shared interest in our struggles and lack of prior education and training in addressing the problems that these patients who are incarcerated or under the custody of law enforcement face. We kind of connected through the ATS, and from there have founded this organization to advocate for and educate clinicians, advocate for patients and educate clinicians, the types of things that we wish we had known back 10 plus years ago when we first encountered patients like this.
And we've created a website with information, ideally for folks to access when they have questions, that they can get the answers right away. We view it as like a 2 a.m. resource for people to log on, find the specific question they have, get some guidance, and kind of learn how to proceed in a sort of ethical and legal way.
And so,
I view your website, by the way, scopesandshields.org, as like the up-to-date of caring for people in the custody of law enforcement. So everybody should bookmark this site and remember it at 3 a.m. when you need to think about some of these thorny issues that you will think on 10 years in the future.
And while it's it was written largely by clinicians, we also have collaborators who have legal backgrounds. It's not intended as legal advice, but at least legal education. So it's not just written by doctors.
Man, I think that's just such an incredible resource, and I'm glad to now know about it. It's not something that I use a lot in or have to deal with as often as maybe others in practice, but certainly something I have seen. It's great to know there's a resource like that, and it's so eye-opening and emotional for me to hear your reasons for getting into this this kind of very important but not very well understood or well known kind of corner of medicine. It's just those stories, both of those stories, really strike me, and I'm so glad to have you guys on. I know we've got a lot to get to, so I think it might be helpful, Nick, for us to maybe just outline a little bit of the topic at hand and why we think it's so important. We know that, at least in my training, but perhaps not as much now, but in my training, I saw quite a few patients that were under the custody of law enforcement in the hospital with critical illness. And I'd often ask myself, how do I approach this patient? How do I have to run things by the law enforcement officer before I do X or Y? I mean, I'm supposed to be the medical professional here, and I'm trying to take care of this patient. It's just to me, it was always uncomfortable, and I'm hoping we can demystify that interaction a little bit. This is particularly germane to those of us that practice in the United States because, unfortunately, we do have the highest incarceration rate in the world, with over 1.2 million people incarcerated in the United States, and that's further, I suppose, upsetting because we have about 4% of the world's population, and yet we have 25% of the population of incarcerated individuals worldwide, between our U.S. prisons and jails.
Yeah, I think the U.S. really does have an enormous number of people who are in the criminal justice system, and therefore, as physicians, we see those people when they require higher level of care. I think many of our listeners are aware that people who are in the criminal justice system are entitled to health care. This comes from a Supreme Court ruling that found that the deliberate indifference to the serious medical needs of prisoners would be wanton infliction of pain, which would be cruel and unusual punishment. But what I think a lot of people may not realize is that while people who are incarcerated are guaranteed essential care, this care often falls short of what they actually need. For example, during COVID, we saw very high rates of COVID infection and COVID mortality in prisons. And I feel like this is something where this is an issue of access to a scarce resource. For example, vaccines. And the lack of access led to many people coming from prison to ICUs for respiratory failure due to COVID. And that's just one example.
I think we have some great cases lined up that we really want to get to. And I know that we want to be respectful of our guests' time. So I think that's probably good enough to lay the framework for why we think this is an important topic. One other element, I suppose, though, before we really get into the meat and potatoes, would be some definitions of terms. Matt, Erin, I was hoping we could talk about terms like custody, LEO, jail, prison, and kind of just let us know what those terms really mean in the context of what we're discussing today.
Sure, I'll start. One of the comments that we have gotten from providers who care for patients is that they don't know the patient's status and at any given time. And there are a lot of different statuses between when somebody, is first encountered by police in the field and picked up versus to when they're kind of incarcerated and in prison. And so, before when someone is brought in by police immediately following their arrest, they're in custody, which means they haven't necessarily been charged with a crime or convicted of a crime. And so it's important to know that there are many, to familiarize yourself, and you can look on our website, we have some information about kind of the different stages that people move through in the criminal legal system. But I think it's important to be aware that there are many patients that you will be taking care of or you will encounter that have law enforcement officers with them that have never been even charged or convicted of a crime. They're just sort of in custody, and the law enforcement, essentially is there to prevent them from absconding or to potentially protect you from harm or protect them from harm, but not necessarily there because the patient's been convicted. And so it is, we'll get into some of the questions you should or shouldn't ask when you're caring for these patients, but I think it is helpful to understand at least where the patient's status, has this person been charged with a crime? Has this person been convicted of a crime? Is this person incarcerated? To understand kind of that. And the other term we might use is LEO or LEO, and that's somewhat of a standard definition or abbreviation for a law enforcement official. And the key thing that is important to understand is that a lot of the cases we'll be talking about are law enforcement officials and not hospital security personnel. Hospitals are allowed to set their own policy. They are private businesses often. They are not truly public spaces, and so they can set their own security policies and determine, who's allowed to enter, what that person is allowed to do, sort of set up these sort of contracts with visitors. That's different than a law enforcement official who is enforcing the laws of the state, the city, the county, the federal government. And so it's important to kind of differentiate a law enforcement official from a hospital security person. We'll touch into that as well.
As we talk about terminology, another set of terms that is quite confusing to a lot of people is what is a jail versus what is a prison. A jail is usually run by a municipality, so a county or a city, although occasionally they are run statewide, and that is a place where people who are even pre-trial, pre-arraignment can be housed. And people who have gone through the trial process and have been convicted, but their sentence is less than a year, can also sometimes serve out their entire sentence in a jail and never move on to a prison. Prison is the facility that is run either by a state or federal entity that will house people who have a sentence typically longer than 1 year. And so you can think about how that might have implications for our patients, thinking of jail as a more transitory facility with a lot of churn, a lot of in and out, whereas a prison is a more established population. Not to say that there isn't a fair amount of turnover there too, but where somebody might expect to potentially establish care and receive health care over the course of years or even decades.
That's a very helpful set of definitions, and I think that demystifies some of the terminology. Are there any terms that we should avoid using?
Yeah, you'll hear Matt and I try to really intentionally avoid words like inmate, prisoner, convict. words that kind of foreground the criminal legal history of the individual and refer to them instead as persons who are incarcerated or incarcerated patients. And so we're trying to model that person first language that's been advocated both by formerly and currently incarcerated people and other academics.
I think that's so helpful to underline, Erin, because I know in medicine, even as I was going through my training, there was a significant shift from sort of referring to the quote unquote cirrhotic or the alcoholic, and instead using terms like the patient suffering from cirrhosis, the patient suffering from alcohol use disorder, which, at glance, at face value, we may not really realize the impact of making that distinction, but it's so tremendously important to put the person first and not put their condition or their situation first. And I think it helps, for me at least. I actually feel like it's helped with moral injury. It's helped with me sort of framing the patient in a more humanistic way. And so I'm really glad that same principle conveys, to this scenario.
So I think we should probably get to our cases and talk about kind of specific examples that our listeners will probably relate to, and kind of what are some of the key principles to understand and what are some pitfalls to avoid. So our first case is we're going to touch on some privacy issues. And here's our hypothetical. You're caring for a man with a GI bleed who's in police custody. You go to the bedside to discuss results of his workup for liver disease. His blood tests have tested positive for hepatitis C. You notice that there is a law enforcement officer sitting in the room. Matt, how do you proceed in this setting?
Yeah, great. This is a common question that comes up, is sort of health privacy. Essentially, that's the issue we're discussing now, is how, what rights to privacy does this person have who's in police custody? And many of us know about HIPAA and, train ourselves on our responsibilities in terms of HIPAA, but often when faced with an authority figure, like a law enforcement official, we may forget some of the things that we learned in our HIPAA trainings. And so essentially, a hospital is a covered entity, which means that hospitals are responsible for maintaining privacy. And law enforcement is not a covered entity. They are not responsible for maintaining privacy. And so it is our responsibility as providers, our legal responsibility, to maintain the patient's privacy. So that needs to be kind of clear, is that we are responsible for maintaining their privacy. The law enforcement officer is not responsible. So we are an advocate. And so that patient's information, those test results, any discussions you're going to have are private. That's protected health information. Whenever we discuss sort of test results, previous care, past medical history, future care plans, all of that is protected. And so, for this gentleman, when we discuss what we think is causing his GI bleed, what we think the plan will be for his GI bleed, what his test results show, all of that is protected information that should not be disclosed to law enforcement without his permission, his express permission. And so the correct thing to do would be first to assess safety. Again, we can't provide healthcare if we are not safe, if we are at risk. So, it's important that you, ensure that you are safe and comfortable in the environment you are in. If you perceive that you are safe and do not need the protection of a law enforcement official, or if you feel like you're not safe, you can always engage in hospital security. That's somebody they are employees of the hospital like you are. They are a covered entity, and so they are also bound by HIPAA disclosures. So it's always okay to ask for a hospital security person if you feel unsafe. You do not need to rely on law enforcement. Again, it's these sort of who is and is responsible for privacy. As long as you feel safe and you've gone through that step, ask the officer, the law enforcement official who's not a hospital employee, to leave the room and have the conversation you would normally have. That should always be your tactic, is to protect privacy and have hospital security do their job, law enforcement step out of the room if they need to be there. I think, and that's just, I think that as physicians, especially, ICU docs, we like following templates, guidelines, following rules, and it's very easy to just defer to somebody standing there telling you that I can't leave the room. My boss says I can't leave the room. if that really is the case and you run into that situation, there are shift commanders and watch commanders that can be reached. We have some kind of nomenclature on our website, and kind of depending on whether the officer is coming from a federal or municipal setting, whether they're coming from a jail or a prison, there are kind of different terminologies of who their boss is, but you can always check and make sure that what they're saying is accurate and that they do have an obligation to stay at bedside. But your default should always be, to uphold your legal responsibility to the patient and ask them to leave the room and protect their privacy. And that includes for exams, procedures, discussions, kind of anything that would involve protected health information.
My understanding is that sometimes law enforcement officers are instructed to maintain a line of sight so that they are supposed to be able to see the patient, but it may be possible that they can still maintain that line of sight from a greater distance and preserve some of that, the privacy of the conversation, or there may be ways in which through draping we can perform an exam that doesn't compromise the privacy of the patient. I would emphasize, just like Matt has said, that this should be a conversation that we hold respectfully at the bedside, or just removed from the bedside with the law enforcement officers. I've found them to be quite collaborative as a whole. I mean, not down to every individual, but in general. Usually when I've asked for additional privacy or distance, they've helped me understand what is possible and what is not possible, and doing that with kind of that intention of upholding the dignity of the patient and explaining why we're asking this, has usually been met with a collaborative response.
Yeah, I would agree with that. Just walking up to somebody and saying, "Get out of here," is not going to be as effective as kind of explaining your rationale. And I think, doing what you can to accommodate things like line of sight, as long as there's not a privacy issue, are reasonable.
I think those are great points.
There are certain in HIPAA, there are certain situations where covered entities such as physicians or other healthcare providers are allowed to disclose health information to law enforcement. I think that I think the best thing to do is probably to look at HIPAA itself or go to our website where we'll direct you there. But the key, things are if ever there is a court order or a subpoena that is produced, they can produce that you have to provide information. Certainly, we would advise you to comply with that. Other scenarios are where a patient tells you that they've injured someone outside of the hospital, or that there is someone injured outside of the hospital. You're allowed to kind of share that information. If somebody at your hospital, another employee, is injured, you're allowed to communicate that, to the law enforcement officials. If there is a communicable disease, you need like TB or COVID, that needs to, that can be disclosed. So there are others, and there's other situations too. And I advise you just kind of familiarize yourself with those.
Yeah, I think that's a key set of exceptions, but I think the underlying principle is really important to emphasize to our listeners, which is that people who are in the custody of law enforcement have a right to privacy. And if you talk to them with law enforcement officials present, you have violated their privacy potentially. And so the sort of correct course of action is to ask for some distance, maybe bring in hospital security instead of LEOs to sort of provide safety if you need it, but to have that conversation out of earshot, because you don't want to have a conversation. You wouldn't have this conversation in the lobby of your hospital. You probably shouldn't have this conversation in front of people who aren't bound by HIPAA.
Yeah, I think a key way to frame, how you think about law enforcement's role and sort of privacy is like they're another visitor that is in the hospital that has not been kind of invited by the patient. So sort of the same rules that would, like your lobby comment is maybe a correct one. Of they're someone who's been allowed into the hospital, but they are not there at the sort of request of the patient. They're just another visitor in a sense.
That's a great way to frame it. Absolutely. So, we could probably talk endlessly about this topic of sort of the edge cases of privacy where you have to weigh, the benefit to some third party versus the privacy right of the patient. That's the heart of medical ethics, is often about questions like this. What are some resources that people can use, like when they are facing one of these harder edge case discussions, like when they're not sure what the right thing to do is?
So one thing to understand, I think, is, well, familiarizing yourself with the law is important, both federal laws like HIPAA and your state laws, and just being generally aware. And that, this is something that's been kind of news to me as we've investigated this, is the hospital council or the health system council represents the health system and the hospital. They don't necessarily represent every provider, individual providers. And so I think that, if you, so it's some ways it's up to you and to kind of protect yourself and familiarize yourself with these laws. There's like kind of no obligation. We've learned kind of talking to providers from all over the country who've been in some of these situations that the hospital general counsel of the healthcare system and the hospital isn't necessarily there to defend them and to represent them. So asking that person a question or asking risk management a question is a reasonable place to start. But you may, ultimately the responsibility kind of falls on the individual. And that's why we made a site like this, just to provide, a quick and easy way to try and educate yourself. There are so many local laws and state laws that, we just can't include all of them on the website. So, we tried to do as best we can to give you just a general overview of the topic. But there really isn't, other than hiring a lawyer yourself, which many of our legal advisors have recommended, is everyone kind of have a lawyer, that they can consult with some of these questions. But in the heat of the moment, you just have to do your best with the education you have and the resources you can find.
Got it. Yeah, I think just emphasizing to our listeners that it's really important to be mindful of privacy and mindful that saying things in the wrong context could violate the patient's rights to privacy, and that there are exceptions, right? There are mandatory reporting situations, but aside from those very clear-cut cases, you should be careful to protect yourself from inadvertently breaking laws and violating your patient's rights.
Yeah, and we didn't touch a lot on mandatory reporting, but mandatory reporting varies significantly state to state. So that's something, again, even if and locality to locality. So you really need to do from who is required to be a mandatory reporter and what crimes or sort of situations are generally child and elder abuse, and generally victims of crimes are sort of, those are covered under mandatory reporting laws. But there are sort of unique things about, in some localities dog bites have to be reported, and some localities they don't. In some locality, and so just little burns have to be reported. Other localities they don't. So there's just little differences to familiarize yourself with.
I think that's a great discussion.
Yeah, so like so much in the U.S. healthcare system, there's non-rational variation from one place to another. So learn your local laws. Check out the website is kind of the good places to start.
Great discussion. Really, really great. Tons of information there. I think in the interest of keeping things moving, we can maybe move on to another case and discuss bias. Situations where bias could arise. So Erin, maybe you can comment on this. So suppose we're caring for a gentleman who's brought in from prison with respiratory failure due to pneumonia. He's got a distinctive last name, and your resident ends up Googling him. He starts reading up on who this person is, and comes over and says, "Whoa, you'll never believe why this guy's in prison." So Erin, what would you do in that situation? How would you approach that patient appropriately?
Yeah, so I'd ask them to press pause and not tell me. Would be step one. And then I would say, my opinion here is that Googling somebody or trying to look through the local newspaper and understanding what the charges have been, what the conviction may have been for a given individual, that falls far outside of the scope of my responsibilities to them as a clinician. And I also worry that it introduces a tremendous amount of bias in my interaction with that patient. I have a responsibility to that patient to attend to their health and their well-being, regardless of the things that transpired before they came into the hospital. And that can be a really difficult pill to swallow, I think, for a lot of people. And we're hearing, becoming a very common practice that when you have an incoming patient, before they even hit the door of the ICU, somebody on the team has looked up the patient and knows some contextual details about their criminal legal history that I think unfairly, bias the healthcare team against the patient before they have their first interaction. So to me, it's a matter of ethics, but it's also a matter of professionalism and thinking about what we need in our professional role to provide the best care to each individual patient. And so I would argue that that means blinding ourselves to what their criminal legal history is.
Let me ask a follow-up question, because I think there are circumstances where, despite your best efforts, you might catch wind of what this person did and why this person is in prison.
Sure.
And so my concern, this is something I've wrestled with from my times working in surgical ICU, is, do you have any strategies from your own clinical experience to try and compartmentalize crimes that may be triggering to you as the clinician and focus on taking care of this patient the way you know how? I mean, what can we leave our listeners with in regards to that?
That's really tough. And I think that there may be circumstances where for an individual clinician or team member, it's just not possible to care for a certain individual. And we should allow kind of the space and the grace for people to step aside if they feel like they are unable to, for whatever reason, provide excellent care to the individual in front of them. That's really important. And so if you happen to already know of this individual before, through reasons beyond your control, before you assume their care, and this is a triggering situation for you or for somebody else, I think hopefully your bench is deep enough that somebody else can step in and help in that capacity.
Thanks, Erin. I'm really grateful for you making that point.
We don't want to frame that as I would say we don't want to frame that as a shortcoming that someone would have, that they have
Right.
that response. It's just it's important to recognize it in yourself and acknowledge it, and just make sure that the focus is on the patient getting the best care. And so, I think that a lot of, we've had here in Colorado, we have a hospital that many people convicted of very serious crimes come to, and it's important, I think, for each person to make sure that they're able to practice without significant bias, and if they can't, to hand that off.
The same way that we would choose not to provide care for a loved one or a family member. I think if we feel like we can't provide really great care to somebody, if possible, we should find somebody who can.
Yeah.
I think that's a really good way to bottom line it.
If we can't be objective, or if
Right.
the provision of that care would be so distressing to the individual clinician. And I agree with Matt about that framing. It's important that we acknowledge that this isn't a shortcoming of the clinician. In fact, it's an admirable and brave thing to admit that.
Well said. All right, moving on to another case now. So you're caring for a woman who was admitted after a motor vehicle collision. It was a low-speed collision of car versus lamppost. The patient is confused and unable to speak. Brain imaging discloses a large right MCA ischemic stroke, which you suspect is likely the reason why there was a crash. Police are investigating the accident. They're concerned about drug or alcohol use. They ask you to draw blood and urine for, quote, drug and alcohol testing. How do you proceed in this situation?
That's a good question. A simple answer is that in most states, I think 49 out of the 50 states, there is something called implied consent for alcohol testing. And that means that when somebody signs up to get a driver's license, they actually sign away their right to declining testing for blood and alcohol if they are incapacitated. And so this person has essentially already consented for the testing that the officers are requesting. So that is different than if they were to ask for, the results of her CT scan. They would like to know the results of her CT scan. Well, she hasn't, you don't, again, because of the privacy issues we discussed before, you don't have to disclose that to them. Or if they wanted to know what her blood glucose was, and maybe they suspect that is the cause of the crash. You do not have to check that if it's not otherwise medically indicated. But alcohol and blood, technically the person has already consented for that. Now, the question is that often comes up is, okay, so this patient in my ED has consented for this, like they've signed a consent document. Do I have to draw it? And the answer is no, you don't have to draw it. And this is, it's a famous case of a nurse in Utah, Alex Wubbles, who, was captured on video, refusing to draw a blood test in somebody that was in police custody and was arrested for this. And ultimately, was not charged with a crime or convicted of a crime, and was in fact, publicly, sort of apologized to, because there is no law that compels us to perform tests that are otherwise not medically indicated. Now, if you felt that being aware of the patient's intoxication is important to perform a neurologic exam given her stroke, and therefore it were indicated for you, then, again, you have an ethical obligation to provide necessary care for your patient. So this case is a little bit tricky, but I think that, the key issues that we would highlight is that, you don't have to provide any sort of care for somebody that's not medically indicated, that is demanded by a law enforcement official, and that the only test that that you reasonably could expect an incapacitated person has consented to is alcohol testing, and that's because it's included in most driver's license applications in the country.
Great. I was thinking of some follow-up questions, but I think you hit all the points that I was gonna ask you about there. So the bottom line is, you don't have to do unnecessary testing. And even if somebody has consented to an alcohol test by virtue of having a driver's license and being behind the wheel, you don't necessarily have to draw it. And you have a right to refuse if you don't think it's medically necessary.
Yeah. And again, thinking about key terms that we are legal terms. So if you were to provide an medically unnecessary procedure, such as phlebotomy, on a person without their consent, that is considered battery. That's a term that, should, when you think of that, you often may think of a completely different scenario, but that's the term that is often used for, performing procedures on people that are not medically indicated. And so that's where that would fall. And again, if you commit battery because a law enforcement officer told you to, that's still legally on you, in terms of who's liable for that, committing that act.
Great point. Yeah, that's a pitfall you definitely want to avoid. One other point I just want to emphasize about this case: this is a situation, like we talked about at the beginning, where somebody has law enforcement officials with them, but they have not been arrested, charged with a crime. They're just trying to figure out what happened. And so it emphasizes the point that just because you see this woman, and some police standing next to her, it shouldn't make you think that she has necessarily done something wrong, let alone been convicted by a jury of her peers. Just to remind on that point.
Great point, Nick. Thanks for underlining that. I think if there isn't any more discussion, perhaps we can move on to another case and deal with another issue. So in this case, we've got a gentleman who has respiratory failure. They're on a ventilator. And during your physical exam, you notice that the patient is actually shackled to the bed by his wrist. You note that there's some induration and even some edema around the wrist. So, Erin, I'll ask you, if you come across this when you're evaluating a patient, what are your options? What can you do for someone like this to help this patient?
Yeah. So this is a more clear-cut indication, I think, even than the dignity harm that I was discussing at the beginning of the podcast, where there was a patient who was dying, shackled to his ICU bed. Here, there is a physical harm that seems to be inflicted by subsequent to the presence of the shackles or the hard restraints worn around the wrist. So, the very first thing I would do would probably be to point it out to the law enforcement officer attending the patient and ask if it could be loosened or removed as we try to troubleshoot the situation. I would photograph it for the medical record because this is a medically relevant consequence of the fact that the patient is shackled. and talk about alternate means of maintaining security of the patient and the situation that can involve just not using restraints at all, depending on the situation. Um, it could, it could result in any number of kind of alterations to make sure that the patient remains safe and that the staff and attending officers remain safe. So that's probably where I would start. Sometimes it could be if there is no. So it sometimes will depend, of course, not only on the judgment of the person at the bedside and the person who's back at the prison or jail who has potentially more information about the offense for which they are in custody and their kind of level of security at that facility where they are. May not be possible to remove the restraint altogether, but alternating to another limb or something like that might be possible.
Great. Are there any situations where law enforcement officials are not allowed to place patients in restraints?
Well, due to the tremendous advocacy efforts of our colleagues who are way out ahead of us as intensivists, our colleagues in OBGYN, there has been, and a lot of other people who have kind of joined forces, placing a person who is in labor in restraints is now illegal, as I understand it. And you may have also known, you may be aware that about almost 60,000 pregnant people enter different correctional facilities annually in the United States. And there was just a high-profile case that was publicized in the New York Times of a woman giving birth unattended in her jail cell in Tennessee. That article came out, I think, just within this last week. So lots of important issues still at play for that population as well.
Gosh, that's just like the imagery of that is just chilling. My goodness. Erin, and another, if we could pivot to another question that I often have as it relates to surrogate decision makers, I think that's another common issue that we tackle not infrequently. So suppose we'll shift gears a little bit and say we're caring for a 60-year-old man with sepsis due to an abdominal source. This gentleman's delirious. He's unable to participate in medical decision making. And based upon your assessment, a surgical consult would be recommended for and then following the consult, the recommendation is for an exploratory laparotomy. This patient is incarcerated, and as we stated, is delirious, unable to make decisions. Erin, in this patient, who could we actually contact for consent? How can we move this patient's care along?
Well, sadly, the answer depends on where you are and where the patient is incarcerated, because this is not, there isn't a set of rules that applies across jurisdictions and across correctional settings. Even, for instance, in the state of Minnesota, the answer to this question differs whether the patient is in the custody of the federal system or is in a state prison. I think some foundational things to understand would be that incarcerated people have the right, the autonomy to select their own kind of medical destiny, make their own medical decisions. That does extend to the right to appoint an alternate decision maker in the absence of capacity. So if this person had already executed an advance directive, or even if there were ample documentation in an advanced care planning note or something like that, but especially the advance directive being the most ironclad and respected format of declaring who you would want your decision maker to be in the event of incapacity, then you might have the easiest possible pathway to interacting with that individual. I'm not saying that you can pick up the phone and call that individual. Usually there are policy and correctional facility hospital and correctional facility policies that govern the way in which you make that introductory interaction with the surrogate decision maker or the durable power of attorney for healthcare if there is an advance directive. And so those logistics are often set up, say, by the prison or by the jail. And sometimes there is even a medical official on the phone call or who connects the two parties. So at times that level of kind of surveillance and involvement is dropped in subsequent conversations, but not always. And so it's important to follow the procedures which are in place by and large to protect, the safety and security of all the people who are participating in that patient's care, and can also be in place to protect the safety and security of people who are connected to that patient in the world outside of the prison. Say if that person had a violent offense against a family member, and then that's the family member that you think that you are reaching out to ask for direction around medical decision making. There are just contextual features that you need to do some collaboration with prison or jail officials to help navigate. That said, there are situations in which the medical director or even the warden in certain jurisdictions has a more central role to medical decision making for a patient who lacks capacity. Those are troubling and very difficult to navigate, I'm sure, also for the prison officials who serve in those roles. When the role of the preferred family member or loved one is less clear in decision making for an incapacitated patient. But suffice it to say, there are a lot of different nuances and permutations of surrogate decision-making structures for incarcerated people who lack capacity.
And one thing that Erin didn't touch on, but comes up a lot too, is if a patient has designated a surrogate and they have capacity, or they and they want to share information with that person about their healthcare, or want you to share information with them about their healthcare. There are many scenarios in which law enforcement officials will say, you can't share this information, whatever piece of information they've deemed you're not allowed to share. And for the most part, there are no laws kind of outlining that right of theirs to forbid the transmission of protected health information between a patient and kind of their kind of designated or surrogate, for example, in order to keep them informed of what their kind of health status. And so that is something that you really need to be. Again, there are certain, we kind of initially on our website came out with a blanket statement that you should, sort of never comply with these rules, but we have found there are sort of locality differences. Again, there's 50 different states and how many different counties, and each one can have a different policy, but there's no blanket federal law or case that says you cannot share information with a patient's that you're forbidden from transmitting PHI securely, that it has to be sort of overseen by law enforcement.
I guess the way I internalize this is patients have a right to choose a surrogate decision maker, and they have a right to share information with that person. The question is how you share it, not really do you share it. And there may be policies and procedures for how you communicate with this person, but in general, you should be able to communicate with them if that's what the patient you're caring for wishes.
Correct.
The other thing that I would add is that people who are experiencing incarceration have very high rates of estrangement from family and friends in the outside of the prison and jail setting. And I think probably the longer that sentence marches on, the more strained and distant those relationships might become. And so we see this increasingly in an aging incarcerated population, that individuals come into the hospital and lack capacity, don't have an advance directive, or even they do have an advance directive, but it's a living will and it doesn't designate a surrogate decision maker. And the healthcare team is trying to figure out how to make decisions for this incapacitated patient. And again, this depends on the jurisdiction in which you're practicing. But by and large, unless I would advise, unless there is a statute or some other piece of policy that you see in writing, I would not involve prison officials in an official capacity in surrogate decision making for that patient. That's not to say that a social worker or a PA or an NP or a physician who works at the prison, say, wouldn't have really useful and rich insight into that individual, who they have been, what their preferences and wishes have been articulated to be in the past. It's just to say that you should follow whatever standard practice you have in your hospital for unrepresented patients, as opposed to just defaulting to working with the warden or something like that, where there can clearly be kind of a dual loyalty or a role conflict. It's best practice, best medical practice to conform to whatever your practices are around surrogate decision making for an unrepresented patient in any other situation, and not treat them differently because they're incarcerated.
That's a great point and a great summary. This brings us to our last case. So prisons are poorly equipped to care for elderly patients and those with chronic medical conditions. The combination of an aging prison population and the COVID pandemic resulted in an exponential rise in the number of people who died in custody each year. Let's talk about another case that kind of summarizes this. So you're caring for a 63-year-old man admitted to the ICU with septic shock due to pneumonia. In the course of his workup, you discovered that he has a squamous cell carcinoma of his lung obstructing his right mainstem bronchus, as well as metastasis to brain, liver, and bone. His septic shock has now resolved with antibiotics, but he has a substantial amount of pain related to metastasis. How would you approach caring for this patient at this point?
Essentially, you would care for him like you would for any other patient. You would not want to sort of, limit your care based off what you perceive is available in the prison where he is located. You'd want to give him kind of all the care anyone else would receive. And then if you think, and again, being a provider or involving other specialists and together as a team, you sort of come to the conclusion that it's not feasible to deliver the care he needs without kind of regular interactions with the healthcare system or monitoring or access to medications that might be difficult to get in a prison setting. If you as a team, after talking to your specialist and coming up with an appropriate care plan for him, have concerns about the ability to get the care he needs in his current setting, there is a process called compassionate release. And compassionate release policies, just as in everything else we've talked to, there's probably, if you take the 50 states and District of Columbia, there's probably still 52 different compassionate release policies you'd have to deal with nationally. And luckily, there's a good clearinghouse website. I'm not saying it's the only website out there, but there's a group called the Families Against Mandatory Minimums, or FAM, and they have a great resource on their webpage, kind of a report card state by state, and more importantly, the person you should contact in each state. Usually it's the head of the state parole board, but usually you can find that person's contact information if you Google long enough, but FAM has done a great job of kind of assembling that information into one setting, and it's important to know that anyone can reach out to this person and say, I'm concerned that my patient cannot get the care that they need in this setting, or that it's not safe for them in this setting. Let's say your patient, has advanced stage dementia and, needs kind of reorientation and kind of assistance with ADLs, and you're concerned that the hospital may not have the resources available to assist that person with their ADLs. There's never, there shouldn't be a barrier to pursuing compassionate release. And it can start with something as simple as an email. And there are many groups out there of lawyers and of doctors who are helping these compassionate release requests that you can find. And again, FAM wouldn't be a bad place to start. You can also look for local organizations in your area that have a history of pursuing these in your locality. But essentially, apply for compassionate release. Compassionate release usually ensures that the person goes to is under parole, so they're still under some legal supervision. They're just in a setting that is more appropriate to get the care they need or safe for them.
I would just add that we don't have eyes into these facilities from whence they come. And so a key collaborator in that decision of whether or not they can receive medical standard of care once they leave the walls of your hospital would be the medical providers within the prison or the jail. And often I've found those conversations to be very fruitful, lots of compassion and interest in meeting the needs of patients and figuring out whether they can be best met kind of within the carceral system or through compassionate release.
Yeah, and I think that's a great point, Erin. I think as much as you can kind of interact with the healthcare team in the hospital, in the prison or in the jail, we would strongly advise you to do that, to kind of understand what they're seeing, and just as you would talk to the patient's PCP, if you had a concern about care collaboration and post-discharge care, do not exclude these people, and they may not be as easy to find as the PCP, who's in your system and who can forward a note in Epic. But again, it's an obligation of sorts to kind of provide that continuity of care. And so, yeah, we would, just as you would involve the PCP in a decision to pursue, kind of a hospice or a change in care status, you should certainly reach out to the docs in the jail or the prison. And again, it's as simple as having your social worker find out who that is. It's not under your obligation. Just as, again, you wouldn't try and figure out who the patient's PCP is on your own. This is in most settings. You have people that can do that for you. You can ask your coworkers and your team to do the same tasks for you. And we just want to highlight that a lot of these docs are working in very difficult situations. And we're not trying to say that, patients cannot get good care in these settings because they lack qualified providers. We're just saying, prisons and jails are not, skilled nursing facilities. They're not long-term care facilities. They're not necessarily equipped and staffed to care for all range of chronic and terminal conditions. And so, there are specific circumstances where that would be appropriate, but not.
I think that's a great point. And yeah, and I agree with you. I mean, basically all of the people I've ever met who work in healthcare and prisons are just truly unsung heroes who are doing the best they can. But for a patient like this, who's likely to either need palliative care or palliative chemotherapy and radiation, prison may not be the best place for them to receive that care. And as a physician, you can advocate for compassionate release for this person. And that's something that we probably ought to do more as we see an aging prison population with more and more chronic illness. There's more and more people whose needs are not going to be met in the prison system, and we're going to encounter them in critical care as they become too sick for the prisons. But then when we think about that transition of care, where is the right place for them to go next? Compassionate release is an important thing for our listeners to remember is an option, and it's something that we as providers can advocate for.
Nick, I think that's an excellent point to sort of end on for the majority of our time here. I know that again, we want to be respectful of our incredible guests here. So perhaps as we close this out, we've covered a ton of ground. We've really just scratched the surface, unfortunately. But perhaps maybe starting with Erin and then Matt, if both of you could provide 2 or 3 really important take-home points that you'd love for our listeners to take with them as they care for these patients.
Yeah, I would say that what I've learned through this journey of interacting for and advocating for incarcerated patients is that, to take a deep breath and to get a little bit uncomfortable. It's not a natural role for me to have a challenging conversation with a law enforcement officer or the warden of a prison. But I've been able to lean into my role as a physician, which I have found to be a surprisingly powerful and respected role in their sphere. Remember that these patients that we're talking about today have largely transitioned over the threshold into our hospitals. They're on our turf, and it's our responsibility to make sure that their care is as good as it can possibly be while they're with us, and that we can make good transitions of care when it's time for them to leave the hospital. So I think just kind of leaning into that, the fact that we have also a leadership role that's acknowledged in society, that law enforcement has a lot of mutual respect for us, and that if we have these conversations in a respectful and collaborative manner, I've found that that goes pretty far in affecting the kinds of change that I want to see, and that we really start one patient at a time. I mean, clearly, Matt and I have been inspired to try to affect more change across our profession, but each clinician has the power to really improve conditions for any patient that they come across who's in the custody of law enforcement.
Yeah, I would just go back to my story that I told at the beginning and how uncomfortable I was. This woman was shackled in the last moments of her life and was denied visitors. And something I didn't mention then, and I should mention, is I never asked for any different care for her. I just sort of, this is what was happening. That's what somebody told me was the rule. And like Erin's saying, that's an incredibly powerful point, is we're educated people. We're viewed relatively positively in society, and law enforcement is not there to antagonize us. They are doing their job as well, and they are often willing to engage in a reasonable conversation with us if we just ask them. So that's the key thing, that we are so ingrained in this profession as rule followers. I mean, very few rebels make it into medicine, and probably, I don't know, critical care, what our phenotype is compared to the general medical population.
They're all in the ED.
Yeah. We all like protocols and checklists and things like that. That's kind of one of the things we pursued. But I mean, just ask, and often you'll be surprised at what happens. And I think just another little point that we didn't touch on much here, but that is also important to leave with. And what Erin said is our trainees. A lot of us have trainees that are with us at the bedside. And I was a trainee, and Erin was a trainee, kind of going through these experiences. And if my attending had just pointed out to me, some of these issues and had been familiar with them and advocated for my patient, it would have gone a long way for kind of changing the way, changing my experience. And so we have a role not only to our patients, which I hope we've outlined in this, of maintaining their privacy and ensuring they're treated just like every other patient that you would take care of, but also as leaders of our teams to kind of prevent moral injury in other people we work with.
I think those are fantastic points to end on. Where can our listeners learn more about your organization?
So Nick has already plugged our website of scopesandshields.org. We also are on social media, on X, formerly Twitter, of @scopes_shields. Those are the two main places you can find us. And maybe potentially coming soon to the famous Dr. Mark's one-pager website.
That's right. Yeah, we're going to plug that in a second. That there's going to be a one-pager about this topic too, coming out in the next few weeks, probably when this episode airs. So on that note, I think we've come to the part of our episode where we like to say thanks to our amazing guests for their dedication to this topic, and for sharing the wisdom that they've learned in this journey with us. Thanks to our listeners, especially the people who have emailed or given us shout outs. And of course, those who have left us 5-star reviews. We like you especially. We appreciate your suggestions, feedback. So thanks to all of you.
We really hope you enjoyed our show. If so, please be sure to subscribe, give us a like, and please, please, please do leave us one of those 5-star ratings on your favorite podcast app. This helps us tremendously expand our audience, and it means the world to us. It's especially meaningful when we have episodes like this one that we can really promote near and far. So please take the time to give us that rating. Additionally, we'd love to hear from you guys. You can tweet X, Y, Z, whatever you choose, to us at Critical Care Time. You can tweet directly to Nick at Nick M. Mark, or myself at Askins_Razor. You can also follow us on Instagram and Threads, and that would be via critical_care_time. and you can check out our YouTube channel, Critical Care Time.
We'd also like to say a big thanks to our sponsor, C-Star Medical. We're fortunate that and grateful that this episode, like all episodes of season 1, are sponsored by C-Star Medical. C-Star Medical is advancing the science of cell-directed extracorporeal therapy to help restore the balance of a dysregulated immune system in acute kidney injury and sepsis. They recently published some exciting papers. You should check out their website, cstarmedical.com, to learn more.
And before we go, we'd like to thank all the incredible members of our podcast team for helping to make this show possible. We'd also like to thank our production team over at Podpaste, and last but certainly not least, Kurt Belknap for our awesome theme music.
Yeah, lastly, just a few disclaimers. This podcast and all related media, including the one-pager we alluded to, are property of Critical Care Time. So please share our content near and far. We only ask that you say where it came from and cite the source.
And of course, the views expressed within this podcast and any associated media do not necessarily reflect the views of our employers. All references to patients or encounters have been modified to be HIPAA compliant, and thus any similarities to real-world cases are indeed purely coincidental. Finally, this podcast is for educational and entertainment purposes only and should not be used in lieu of seeking medical or, especially topical on this episode, legal advice. With that, thanks again for listening. I am, once again, and always will be, I think, Dr. Cyrus Ask.
And I'm Dr. Nick Mark. See you all soon. Thanks for listening.